Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense here on YouTube. So what happens exactly at an appeals court? Well, I'll have an answer for you in just a second. A court of appeals gets involved when someone files a notice of appeal. Basically, a notice of appeal is simply a document that says, we want to take up several questions of law, and here they are. And then the Court of Appeals dockets the appeal. It sets a timetable for briefing. The appellant files his brief. The appellee, or the person who is responding to the appellant, sometimes called the respondent, files their brief. And then the appellant files a reply. The appellant gets two cracks at it because they have the burden of persuading the appellate court that the trial court got it wrong. So then what happens is the courts review those briefs and they set the matter for oral argument. Now, oral argument, it probably sounds like somebody gets up and rambles on for 10 or 15 minutes about the case and then sits down, but that's not what happens. At an oral argument, generally speaking, the appellant will get about a minute to 2 minutes to lay the framework for what they're appealing, and then the people on the bench, there's usually at least 3 lawyers. If you go to a Supreme Court, a state Supreme Court, there can be 7 to 9 judges on a Supreme Court, and they start firing away with questions. What about this? What about that? What about the other thing? Even if you may have prepared 9 minutes of oral argument, you still have to answer the questions that the court asks. And you have to answer them quickly, and you have to answer them correctly. And the way that you can tell if a case is going well for an appellant is if an appellant gets a fair number of questions and responds to those questions and doesn't get a lot of pushback from the judges. I have seen judges in federal court and in state court simply say, that's not right, counselor. You're wrong on that. And when a judge does that, it usually indicates that things aren't going real well. But sometimes that's not what happens, and the argument goes reasonably well for the appellant. The respondent or appellee gets up, and the next thing you know, boy, it's on like Donkey Kong. Well, what about this? What about that? How come you did this? What did you mean when you said this in your brief? And they'll go after the respondent as tough as they did the appellant. And sometimes they even go a little harder because they're trying, the appellant has attacked the trial court and the respondent is trying to defend the trial court. And sometimes trial courts don't need to be defended. So after the respondent gets through with his set of oral argument and answers the questions that he's being asked, then the appellant gets to go a second time, usually for 2 or 3 minutes, to rebut anything that the respondent said during their 10 minutes up in front of the court. Now, different cases have different times. Certainly civil matters are usually somewhere between 10 and 15 minutes per side. It varies with the courts of appeal and with, like I said, the type of question being asked. If you're at the Supreme Court and you have a death penalty appeal, you might wind up getting 30 minutes to argue, 30 minutes for both sides. And that doesn't mean you have to use all 30 minutes, but it does mean that you get an opportunity to air out all of the concerns that an appellant may have. The oral argument is very helpful to the court because it allows the court to see what the thinking is in some of these appellant arguments. You can only get so much from a brief. Yes, you can read it and you can understand it, but you don't necessarily have a flavor for the case until the lawyer gets up and starts with the appellate argument. There is a judge out in California, in fact, the judge who is handling the Avenatti trial, who says oral argument is vital. It's vital to the courts. It's necessary in order to ensure that you have justice. Now let me just point out that we don't always get oral argument. That's particularly true in federal court. In the state court, if we have a motion to argue in the state court, we almost always get oral argument. But in federal court, if we have a motion to argue, a lot of times it's just decided without any input from the lawyers in oral argument. Now, courts can do that. That's their right. But I believe that sells the justice system just a little bit short. I believe oral argument is fundamental to getting the issues resolved at the appellate court level. So that's how appellate courts work. I hope you found this helpful, interesting, thoughtful, thought-provoking maybe. If you have any questions, please leave them in the comments down below. If you haven't already, please go over here and subscribe to our channel. Click the notification bell so you can be notified anytime we release a video on this channel. And finally, I would really appreciate it if you'd smash that like button for me, because it really helps the YouTube algorithm know that this is good content. Thank you so much for watching, and I'll catch you on here next time. See you later.